You can go, Juliano.
Bom dia, pessoal. Bom dia a todos para mais esse encontro nosso para discussão dos temas relevantes sobre antitrust nos mercados digitais. O foco da nossa discussão é enfrentar esse dilema entre, de um lado, sofisticar mecanismos de enforcement para análise de práticas anticompetitivas ou atos de concentração em mercados digitais, e, de outro lado, a alternativa de regulação ex ante das plataformas digitais. Muitas coisas têm acontecido desde que a gente começou, acho que o timing foi perfeito, tendo em vista que sobreveio o PL, tem toda a discussão sobre o Digital Markets Act, muitos dos autores e pesquisadores na área estão mobilizados, escrevendo sobre isso, então isso vai abrir várias oportunidades para nós trazermos esses pesquisadores e autores aqui para interlocução. Nós temos disponibilizado no site do Legal Grounds um material relevante, tanto as apresentações quanto artigos que são objeto de discussão, né? E a gente está preocupado também em trazer informação e contextualizar o nosso público sobre os temas que são relevantes, né? Em particular, eu tenho uma inclinação sobre esse tema, que é o tema dos algoritmos, da inteligência artificial, e, obviamente, como nós já discutimos, a inteligência artificial está por trás e é o cerne, né? É um motor que está no cerne do modelo de negócios, né? De empresas e de plataformas nos mercados digitais, seja para direcionamento de conteúdo, seja para direcionamento da propaganda, mas também como mecanismo de precificação, né? Onde aparece uma série de questões importantes, em particular a possibilidade de colusão algorítmica. Então, hoje nós vamos ter a Viktoria Robertson, a Bianca vai apresentá-la a vocês, para tratar do tema da precificação algorítmica, né? Então, acho que é uma oportunidade ótima, né? Estamos aqui honrados com a presença da Viktoria para participar e se engajar conosco nesse debate. And we are now going to shift to English. Viktoria is actually learning Portuguese. She has already spoken some words in Portuguese to us. She's trying to she tried to capture something about what I have said, but we are going to talk in English. And so I give the floor to Bianca to make the presentation of Viktoria.
So good morning. It's a pleasure and an honor to have today Viktoria Robertson, professor and head of the Competition Law and Digitalization Group at the Vienna University of Economics and Business, professor of International Antitrust Law at the University of Graz, and director of the Competition Law Hub. Her research focuses on competition law in digital markets, innovation, and sustainability, and she's the author of Competition Law's Innovation Factor, the relevant market in dynamic context in the European Union and the United States. And as Juliano has said, we have seen raised concerns in digital markets about rapid technological development in artificial intelligence, consumer data gathering, and e-commerce that might really facilitate and exacerbate anti-competitive behavior. Some predicted that algorithmic pricing will harm competition in consumers as a result of uncompetitive behavior among competitors, between suppliers and distributors, and by individual firms. And to discuss this concern, Professor Viktoria will present a conference on algorithmic pricing, a competition law perspective. The word is yours, Professor.
Muito obrigada, boa tarde do meu lado. É um grande prazer estar aqui hoje. Mas, como disse Juliano, vou falar em inglês. So good afternoon from my side here where I am. It's actually afternoon. I hope you can see my screen. Yeah, good. Excellent. So thank you so much for having me and inviting me to speak about this really current topic, which will gather momentum, I would say, in digital markets, which is algorithmic pricing, and what should or should maybe not be done about this from a competition law perspective. Let me just take you through what I'll be talking about in the next few minutes. After a brief introduction, I want to talk about the uniform market price and how this algorithmic pricing could actually really have an impact on competition analysis as such. And then moving to the question whether algorithmic pricing could be seen as an abuse of market power. And I will focus here on European competition law because that is where I am based. But I do think that we need to have this discussion also in a broader sense, which is why it's great to be here with you in Brazil today. And then I'll also move on to some further antitrust considerations when we talk about algorithmic pricing and a short outlook. So let me start at the beginning. So what is algorithmic pricing? Algorithmic pricing are pricing strategies where a computer program automatically sets the price. And usually, of course, that's with the intention of maximizing the seller's profit. And we can have different kinds of algorithmic pricing because, of course, computer programs can be used for all kinds of things. So they could, for example, be dynamic pricing, where an algorithm adjusts prices based on current supply and demand, and that can move very fast. Algorithmic pricing could also be used to implement collusion on prices, but that's not what we're going to talk about today. And then algorithmic pricing can also be used to personalize prices, so to engage in personalized pricing. So the seller would offer the same good or service to different customers at different prices. And those prices are not just determined by what the seller's cost is, but they would be tailored to the individual and how much they might be willing to pay. Now, in an influential work from 1920, Arthur Pigou wrote that there's 3 degrees of price discrimination. The first degree of price discrimination would group customers according to certain characteristics, like students or females or pensioners. We'll get to that in a minute. The second degree of price discrimination, there the price depends on the customer's choice. So, for example, whether I choose a train ticket for rush hour or for a time where few people take the train, so peak and off-peak tickets. And the third degree of price discrimination is where personalized algorithmic pricing might be taking us, which is much more granular and tailors the price really at an individual level. So personalized pricing can be understood as a practice. I rely here on a definition by the British CMA, a practice whereby companies can use observed, voluntarily provided, inferred, or collected information about people's behavior or characteristics to offer different prices to different consumers depending on what the company believes they're willing to pay. And there is empirical evidence that consumers do not like personalized prices that are set by algorithms based on, for instance, their location, their gender, their wealth, where they live, their software, their hardware, their search behavior, or also what they have bought previously. But of course, that alone doesn't tell us how we should treat algorithmic pricing under antitrust law. What we introduced in Europe with the Omnibus Directive is a change in unfair competition law. In this Directive 2019-21/61, the Omnibus Directive. And companies now have to indicate to consumers when prices are personalized on the basis of automated decision-making. So here there is a distinction from price discrimination on the basis of personal relationships and on the basis of algorithms. And this has now been implemented across the European Union. Now, from an antitrust perspective, algorithmic price discrimination leads to a number of questions. The first is, what about the uniform market price if it gradually disappears? What does that do with our discipline, really? And then, does algorithmic pricing impede or promote competition? What are the welfare effects? So just to talk about the uniform market price for a minute. Sorry. So the uniform price, I mean, that it's a bit of a myth because there's not always a uniform price. So for instance, when I buy a train ticket, I'm not surprised when an elderly couple next to me or the students that are sitting in the other compartment have paid less for their ticket, or that there are price differences, for instance, when I buy a ticket months in advance, or even if I'm the holder of a loyalty card, right? So this is third-degree price discrimination because consumers are divided into rough groups. However, when I go to the supermarket, I very much expect that the elderly couple from the train or the students pay the same price for their bananas. On the other hand, if I have a loyalty card or if they come just before the shop closes, perhaps I can expect a discount. If there's an individualized loyalty discount because the shop knows that I'm a banana lover and that makes me go to the shop, then this is price discrimination that targets me as an individual. And so we can distinguish between a uniform market price, which hasn't really existed for time immemorial either, and different forms of price discrimination that we can distinguish and that we already observe in the market. The question is, where do they get their information from, and how is that being translated into a new price? So staying with the idea of the uniform market price, the uniform market price really is a central element of how antitrust law assessments are conducted today. So this kind of economics-based competition law. You just have to think of when we define the relevant market, we conduct a hypothetical monopolist test, or we ask economists to do that for us. So economists would model a price increase of 5 to 10% above the current market price to see whether consumers would then switch to another product or not. And of course, we know the cellophane fallacy, which means that the SNP test or hypothetical monopolist test cannot work if the price is already above the competitive level. But in addition, it also can't work as usual if there is dynamic pricing or also personalized pricing, because then it is no longer possible to determine a largely uniform price. We also have to think about the substance of competition law. A lot of what we look at in competition law are price-based conduct. So be it price-based abuses of market power, but also in anti-competitive agreements. But if we stay with the idea of abuse of dominance, a lot of the abuses that we discuss are actually price-based. So about fidelity rebates, or predatory pricing, or excessive pricing, selective price cuts, margin squeeze. If we no longer have a uniform market price as a reference because it is disappearing due to personalized pricing, then we have to ask, what do we do with this yardstick of the price that we use in numerous antitrust violations? Can there be a replacement, or do we have to change our analysis overall? So I think this is could have quite some repercussions to what extent algorithmic pricing is actually able to push back this idea of a uniform market price that has shaped competition law to some extent. But moving on to algorithmic pricing and what it can do as a possible abuse of dominance, as I said, I will here focus on EU competition law, but I do think that lots of those concepts and ideas will actually we can also discuss them in relation to other jurisdictions. So if we stay with Article 102 of the Treaty on the Functioning of the European Union, which is our European provision on abuse of dominance, you need certain criteria to apply this provision. So first of all, you need to find a dominant position on the relevant market, and then some abusive market behavior, and then you wouldn't be allowed to find an objective justification. Otherwise, there's no abuse. So if we look at the first criterion, the dominant position on the relevant market, here the question, of course, is what is the relevant market in such a constellation? who sets the price? Is it the online marketplace? Is it the seller? If there's an individualized, personalized price, do we actually have individualized, really narrow product markets that are limited to individual consumers? Because that would be a game changer in how we analyze those markets. And then, of course, there's a question of what about the dominant position, and what about the market power? What are the factors for market power when algorithmic personalized pricing is involved? From an economic point of view, it is generally said that a company needs to have some market power to be able to actually engage in personalized pricing, but it's not, so it needs to be able to prevent arbitrage so that the consumers wouldn't be able to go somewhere else and obtain the product for a lower price, or also resell the product at a profit later. But this economic power in personalized pricing, does that translate into market power, or is there actually a different threshold? How much market power is actually necessary for personalized prices from a competition law point of view? So even the ability to set personalized prices, would that be seen as an expression of market power under competition law, or would that not be enough? It's something that we certainly need to consider going forward. And then, of course, there comes the question of at what point could personalized pricing turn into abusive market behavior? And I think it's quite clear that we need to start from the principle that free pricing, the setting of prices, has to be allowed for a dominant company as well. It's a basic freedom to decide what you offer on the market and at what price. So the level of the threshold for intervention should not be too low. And here we can think of different kinds of abuses that could come into play. Exploitative abuses, so vis-a-vis end consumers, but also discriminatory abuses vis-a-vis trading partners. Discrimination as a separate case group could also be considered here for this, these prices that are actually discriminatory prices. And then, of course, as I said, there shouldn't be an objective justification for the personalized pricing. And here, there needs to be quite some discussion with economists, I believe, because personalized pricing means that some people who are willing to pay more for a product will be asked to pay more, and others who are not willing to pay as much, either because they don't have the money or because they don't want to pay more, they would be offered the same product for a lower price because their willingness to pay is lower. And so that can also lead to an expansion of the market. So there would be more quantity sold as well. And the market would also be opened up to some end consumers who would not otherwise have been able to afford a certain product. So that is something that we need to take into consideration. On the other hand, of course, personalized pricing could mean that certain companies just appropriate the welfare gains that their pricing strategy brings, which would then not be in the interest of consumer welfare. But let's look at what European competition law could provide us with as a legal framework for algorithmic pricing. And here I especially look at two examples that Article 102 of the TFEU provides. And that's, first of all, excessive prices, and secondly, discrimination. And if none of those fit perfectly, then we can always go back to the general clause. So let's start with excessive pricing. And this, of course, is about the exploitation of consumers and customers, because Article 102A prohibits directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions. So under that provision, prices to end consumers are covered as well. So the question then is, when is a price unfair within the meaning of that provision? And there's actually two ways to determine this: a price cost analysis and a comparison with other products. Now, the problem, of course, is that this is very case specific. You need to do a case by case analysis. And competition authorities are also reluctant to become price regulators. We have very little case law on excessive prices in the European Union for these reasons. One of the cases was actually a bananas case, United Brands. And there the court said, well, there's a two-step test to assess whether a price is unfair. So first you look at whether there's an excessive difference between the actual costs incurred by the company and the actual price charged. And if that is the case, you ask whether the price is unreasonable in itself or in comparison with other competing products. However, does United Brands test again assume that we can find this uniform market price? Because otherwise it's an individual case-by-case assessment that I have to make every time for each individual end consumer. So then if I have to go and do that, the question is, could I ask, not is the price unfair in itself or when compared to competing products, but is the price unfair in itself or when compared to the price offered to other consumers? So what you could think about here is, staying with bananas, if a banana costs €5 for a banana-loving, multi-billionaire and 10 cents for the child that's paying with his pocket money, then the question is the €5 for the billionaire unreasonable, or would it be unreasonable to charge both the billionaire and the child, let's say 60 cents each? So lots of questions we could ask here, and this is something that excessive prices we haven't looked at under algorithmic pricing so far in the case law. Another article that could fit is Article 102C, which prohibits the application of dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage. But here you got to say, okay, this example in the law is actually tailored to trading parties, which are other companies that you can place at a competitive disadvantage. And while Pinar Ackman has argued quite convincingly that would also need to cover consumers, the more recent case law on the second criterion, this competitive disadvantage, is really stricter. So if you want to go after discrimination, not against trading parties, but against consumers, you would probably have to do so through the general clause. So if we now look at the general clause, it just says any abuse of a dominant position shall be prohibited. And so, of course, as I said, you could also say a possible abusive behavior here could be discriminating against end consumers. And there's quite a few considerations that you'd have to take into account here, like what are the effects on competition of personalized pricing? Does exploitation occur? Does it create an impediment to competition? Can companies rely on the willingness to pay on an individual level, or is that as such abusive? How do we make a difference between price discrimination that's based on automation, so on an algorithm, and price discrimination based on personal business relations? And that, of course, is a big topic, because we all know if you go and want to buy a new car and you drive to the dealer in your brand new Porsche, you'll probably be asked to pay a higher price than if you bike to the car dealer and it looks like you're buying your first car. That is something that occurs regularly. But of course, it's pushed to a new level through algorithms that make use of data that we leave behind online, so to speak. So overall, we have to see what are the arguments in favor, what are the arguments against including algorithmic price discrimination as an abusive behavior. And the question is, do we also look at fairness, at equality, at efficiency? We know that fair economic activity is not always the most efficient. So in the end, we have to go back and ask ourselves, what is antitrust law trying to achieve? And also, how does it interact with consumer rights and data protection, which of course also come into play when prices are tailored based on the personal information about individual consumers. So let me briefly move to further antitrust considerations, because I know my time is coming to an end. And here, I just want to mention that discrimination against other trading parties is also forbidden under the rule on anti-competitive agreements in the European Union. Then another point to take into account is that when you look at merger control, algorithmic pricing could also play a role, in the sense that if a merger is proposed between a digital platform and companies with know-how in the field of personalized prices, data collection, analysis, and so on, then you might also want to take into account whether that could lead a company to engage in large-scale personalized pricing. And finally, I think it's interesting that algorithms can do a lot. They can help you to personalize prices. They can also possibly help in colluding prices, but it's very unlikely to have them both at the same time. So if there's algorithmic price discrimination, then it will be harder to actually implement some algorithmic collusion on prices. So at least they wouldn't exist both at the same time. Okay, so just for a brief outlook, as far as I can see, antitrust law has not yet challenged personalized pricing, and we'll have to wait and see whether it will do so in the near future. I think until then, we still have to make some considerations that could be helpful in the antitrust analysis. One of those interesting facts when you think of consumers is actually that individualized discounts are more likely to be accepted as something positive by consumers than personalized prices, but they have the same welfare effects. So I think we really need to think about how to incorporate consumer welfare, but also the perception of consumers into this analysis. And also, of course, behavioral discrimination does not end with personalized prices. There's much more that can be done with our data online, and algorithms can do that. But I think prices are the most obvious example here. Finally, online and offline are increasingly merging, which means that although we might think algorithmic price discrimination might be a thing of online markets, this is actually moving offline as well, because we carry our smartphones with us, well, to be honest, at all times. So this is not something that stops online. It also goes in the offline markets as well. And it would be good to have a more broader view on this as well. Now, finally, competition law really needs to adapt to current developments. And as I see, the increasing use of algorithmic pricing is one of those. And I'm looking forward to the discussion and seeing what you think about this. Thank you.
Thank you very much, Vicky. My colleagues certainly have questions to you. I have two questions. If my colleagues are okay with that, I would like to start. So,
go on.
Okay. Sorry, I'm always disrespectful with my colleagues because I advance with the first questions. But if you want to make it different today, please feel free. I have no problem if you raise your hands. So I think that there is one very first congratulations for your presentation. I believe that you have pointed out many difficult junctures in this discussion about the legitimacy of and legality of algorithmic pricing. But I would like to think about this challenge that is the very individualization of algorithmic pricing and how it can be adapted to the traditional antitrust analysis, because the analysis in antitrust is always approached by groups of interest. So, for instance, we do not protect competitors; we protect competition as a relevant interest. So we do not protect one consumer, but the consumers, the class of consumers. So we always think about organizations, groups of interest, and etc. And within the antitrust analysis, there is the idea that antitrust is protecting, in the end, consumer choices. So it is the sovereignty of consumers that should determine what companies are willing to produce, how much they are willing to produce, and at which prices they are going to offer the products. But the consumers are thought as this group that has rational deliberations that will move all the rationality among the dynamics of competition, and therefore the antitrust analysis. But now we have this technological possibility to ask what is the will of a particular consumer regarding price, a key aspect of the dynamics of competition. And then we may ask, is the sovereignty of this particular consumer being respected within this model? On the one hand, if we still consider this consumer as a rational being that is going to deliberate rationally around this decision, we may think, well, we are now offering the opportunity for a particular consumer, not for the group of consumers as a class, to make a rational deliberation and decide about it. So on the one hand, you may say, well, this is an opportunity for a real exercise of consumer sovereignty. But on the other hand, as we see, these algorithms are not asking exactly what they are willing, but are classifying this a particular consumer within a profile based on their individual data. So actually, the price is based on what the consumer is, or how he or she is profiled, and not about what she wants. And there's another problem, which is we have also this concern within the use of algorithmic in the relation with consumers, which is the capacity of algorithms to capture sublinear aspects of consumers and also irrational behavior. So you have mentioned that consumers don't like to algorithm pricing, but they like algorithm discounts. So this is an irrational behavior. So and algorithms has this ability to capture these impulses of consumptions and also add discounts with algorithm pricing. And this may move and provoke irrational behavior. And this is the other side of the issue that undermines the idea that we are preserving consumer sovereignty. So I would like to comment on that.
Okay, thank you, Juliano. So some very challenging questions, because they really go to the heart of what we need to think about when we really try and wrap our heads around what competition law should do, if it should do anything about algorithmic pricing. And here I mean algorithmic price discrimination, because like you said, it's really a change of perspective if we look at individual consumers rather than consumers as a group. And as I said, it might also entail changing our perspective on what the relevant market is, in which case it might really be that we have really narrow individualized markets, which is not actually what market definition wants to be about in the first place. But, you know, markets evolve, market behavior evolves, so this might have to evolve with it. Now, in this change of perspective from a group of consumers to individual consumers, I guess what we have to ask is, what do those personalized prices do with competition? Because that's what competition law is concerned about. And of course, there will be some strong interactions with consumer protection and as I said, also data protection. But from an antitrust perspective, we need to say, well, what do personalized prices that are based on an algorithm that's fed with hundreds and thousands of data points, what does it do with competition? Is that something we want to encourage? Is that something where companies with the necessary market power might just appropriate all the welfare that flows from this behavior? Because as I said, economists don't say, well, this is all bad. It can be good for some consumers, and of course not so good for those consumers that are willing to pay more. But if you're not able to pay more or not willing to pay more, then you might be included in the market now, which previously you were not. So then those consumers, for them it is something good, but even such consumers would actually say, from a fairness perspective, they don't want to be charged. They don't think it's right to be charged a different price. But that might also change once we become more accustomed to algorithmic personalized pricing. And I think one point you also made is to say, well, there's also this other type of behavioral discrimination, and using our irrationalities as consumers. And I think that's something that needs to be paid attention to, but especially from a consumer perspective, a consumer protection perspective, because nudging consumers to buy something or showing them certain offers when they're at their most vulnerable, I think that has more of a consumer protection connotation to it than an antitrust connotation, from where I stand right now.
Okay, I'll give the room for my colleagues, and if we have time, I can make my second question.
Hi, Vicky. I'm gonna jump in and make the question. Thanks very much for your presentation. It was fantastic. And I'd like to approach this thing about algorithmic pricing from this trade-off between regulation and competition enforcement. I don't know what you think, because if you think that discrimination is not inefficient, I think it's not inefficient. Then the question is fairness. Why this reason to discriminate? Like, if it's gender, it's race, it's geolocation. Then if it's fairness, don't you think that regulation is a better tool, more designed to approach that than competition enforcement? You can say, no, competition fairness can be a goal for competition, but usually these questions about fairness are better treated as regulation. And if you think about that, this idea of the DMA that has a per se prohibition about some kinds of discrimination, because this is a long history in antitrust and competition law. Let's forbid discrimination, price discrimination, but like from the Robertson Act in the United States. But this has never got into practice, because price discrimination is normal as a market practice. So and I don't know if you agree with that. And the second question is, don't you think that algorithmic pricing can make the market more opaque and make it harder do competition enforcement, because the tools they use price, okay, and if there is not a price for the market, or it's harder to assess a price for the market, for instance, maybe I have to assess that inside the platform. So I have to see what's the market price in Amazon, and to do that I have to in some kind of way talk or have use the architecture of the platform, of the digital platform, and this can make harder to assess the market price, and this could make harder to trigger investigations and things like that. Don't know if you agree with that. And in this way, transparency is enough, or do you have both maybe? Because if you have more transparency on the algorithm or on the reasons of discrimination, when you say like the elderly couple has paid less for the train, but this is very transparent because I know that you have a different ticket for elderly people. But I don't understand, it's very complex. Why it's someone that access the internet on the night pay less, and someone that access on daytime pay more, or something like that? And how do you think about this transparency of the reason of the discrimination? Thank you.
Okay, thank you, Vinicius. Also some very challenging questions there, but let me see how I can address them. So on the trade-off between regulation and competition, I do agree that regulation could be a tool to address algorithmic price discrimination as well. And like I said, in Europe, we've gone down the path of saying in the Omnibus Directive of 2019 that if there is algorithmic price setting, then consumers need to be made aware of that, but they don't need to be told how it is done. So they might know that this is something that's happening, but they still don't have to be told how it's happening. And that links to your second question of the transparency. So I'll get back to that in a moment. But yeah, I agree. If we think that algorithmic price discrimination is something to be tackled, competition law cannot and should not be the only tool with which this is addressed. I just think it could be an additional tool, especially in digital markets where some market players have much more availability of data that they need for this than others. So big platforms will have an advantage in this and might also use that and exploit consumers and are able to exploit consumers more than others. But I think it's an open question how the interplay of regulation and competition should be in this regard. And for this, I think we need more research to really assess the welfare effects of price discrimination, because like we said, there are some good sides and some bad sides. And if it's only the platform appropriating all the welfare, then that's not our idea of competition increasing consumer welfare here. Now, on the transparency question, I think that's really spot on what algorithmic pricing does. It makes prices much less transparent. So if you and me pay a different price, we're not going to be told why that is the case. So it might be because of the time difference between Brazil and Austria, but it might be because we're using a desktop and a laptop, and so there's this. There really is this factor of we can't find out why we're being offered a certain price, because of course nobody wants us to be able to find out, because then we could adjust. And I do think that having or slowly perhaps losing uniform market prices, even if they were never only uniform market prices. We've always had a culture of discounts and so on, but there was something similar to a uniform market price. And if this slowly disappears because algorithms determine prices based on individual willingness to pay, then this will make it harder to go after all price-based abuses, I think, and all price-based behavior under competition law, because we won't have this point of reference. And so I do think it's time now to start thinking of what to do with this before we're really in this position, like you said, where competition investigations are being slowed down or are made almost impossible because of that. And just linking back to the transparency that you mentioned, I think it's important for consumers to know not just that a price is based on an algorithm that uses our data, but also how this is done. And if this is made transparent, then I think consumers have much more, like we said, consumer sovereignty, as we discussed before, to actually decide whether they approve of that or not, and whether that impacts their decision-making on whether to buy a product or not. Because what I read in service is that consumers feel very strongly about this. So if they're not given the possibility to access that kind of information, then they won't have a free choice and a free say in this. But that, I think, is more in the area of consumer protection, but I think it's very linked in this case.
Hi, Vicky. I think that's my turn. I always thought about algorithm pricing on the matter of speed. I think that algorithm pricing make the all economic process of going to the equilibrium more rapidly than the other way around, and it can go for the good or for the evil. So if you find a price equilibrium that's competitive faster, perhaps it's good for you introduce more information. The adjustments of the system go faster, and it's good for equilibrium. It's good for the efficiency of the market. On the other way around, we also could say the same thing about the equilibrium of cartel, for instance. So when we look at the theory of the game theory on cartels, when we think about the prisoner's dilemma, it happens because we just play once, but when we have a repeated game, we can have a cartel between players. And when we have algorithm pricing, perhaps this cartel behavior can be achieved much more faster than otherwise. Could you tell me whether if my thought is right in this sense, and we could say, in some sense, algorithm pricing could be a plus factor when we are talking about a finding of cartel in some investigation?
Thank you, Cesar. So I'm not an economist, just to give you a health warning before I delve into this topic. But I do think that the speed with which algorithms can influence price setting is quite interesting on several levels. If we look at dynamic pricing, of course, that's what makes it possible to have dynamic pricing. And so if we have a different uniform market price every 2 days, then we might not be able to keep up. But also in algorithmic price discrimination, this is really algorithms that make it possible to use the data points that we have online to actually find what could be a good individualized price for one of us. Now, like you said, the algorithms could help find an equilibrium for a cartel, but I think with algorithmic price discrimination, that could also destabilize a cartel, the way I see it, because I don't think you can have both at the same time. So if one of the cartelists would start engaging in algorithmic price discrimination, then the other cartelists no longer really have a way of knowing what price their fellow cartelist is charging at the moment. So if you look at it from that perspective, algorithmic pricing can be something good in the sense that it could destabilize a cartel that might be operating undercover at the moment.
If I may jump in, unless the very algorithms settle super competitive prices.
unless they coordinate with me.
Yeah. HubSpot cartel, for example.
Yeah, of course, that would, you're right. This would be interesting to have an algorithm that, and to have an agreement on an algorithm that actually sets individualized prices, right? And then the cartel does.
I just mean that they can be better than humans to achieve this, because humans have more disagreements or more misunderstandings on setting prices. So perhaps the algorithms don't have this idiosyncrasy. So that's why I sometimes just feel I'm not pretty sure about this. But
there is the risk in highly concentrated markets that the use of algorithm pricing may, given that the algorithms they may be settled targets of maximizing profitability, and they find this equilibrium by setting supra-competitive prices. And indeed having more information about the consumers. So it will be. So this is just a consideration.
Oh, yeah, I agree. The interesting thing is that you're gonna have not the same price, because I think if you think about a very legal perspective, a cartel is an agreement on the same price, and you have an agreement on the same way of determining prices. That is the algorithm, but it's, in my opinion, it's a cartel too. But
and we've had individual cases in Europe where companies would get the same algorithm from a company, and then they were not actually cartelizing on the price, but they were implementing the same pricing algorithm, which leads to the same result, basically.
Like HubSpot cartels, because all use the same. Yeah. Vicky, I would like to make a provocation. Like, we know that in the directive that you mentioned, the Directive 2151, 2019, they say it's okay to have personalized pricing, but the consumer has to be informed. And you have, because it's based on automated decision making. So for one side, we have a right to explanation when you have an automated decision making in GDPR. And on the other side, OECD, when in that study, I think it's 2018 or 2017, Algorithms and Collision Competition Policy, it says that the consumer will also have the price comparison website, even if it has an algorithm pricing and personalized pricing. Consumers can compare prices and websites, but we know that there's a problem of abuse of dominant power by the incumbents in showing prices due to self-preferencing. So what we see is that the consumer really doesn't have any choice. I don't think that personalized price is a bad thing. If I look at economic terms, it's an old thing that already occurred in our lives. It's only deepened now because of the technological capacities. But if I think about a choice of the consumer to see other prices in comparison websites, I will have the problem of the abuse of dominant position in the self-preferencing showing prices.
Thank you, Bianca. So I think you pointed towards an important aspect of this debate here, and it's that there's so many legal areas that need to be involved. Like you said, the GDPR and the Omnibus Directive, which is unfair competition law, and then of course also competition law and consumer protection law. I think what's needed is to try and arrive at a coherent framework. And for that, we first need to find an understanding of what we think price discrimination based on algorithmic price setting actually does, both to competition and to consumers, and what consumers need to make an informed choice and what their rights are. Because of course, when we go on websites and when we sign up for digital services, we consent to them using our data, but not many of us know the extent to which they actually use that data and what they can use it for, so that it might end up costing us more because we pay higher prices for certain things. There's no health warning when you sign up for a digital service that you might pay more for the next flight you're booking online, which is not, which could happen theoretically. Now, on the price comparison websites, I know they're mentioned again and again as a good way to actually get out of an individualized price that's too high. Now, of course, the question is, like you said, who determines what is shown on the price comparison website? And also, do consumers really go there before they're even shown anything? Because it's a question of time and also of knowing your way around the internet, and not all consumers can actually do that. So those who are not able to do that might actually be worse off. And here, I think what we need to look at is how independent price comparison shopping websites actually are, because otherwise they might just be, a good excuse, but they might not actually have any good impact on competition on prices here. So I think that's a very valid point.
Yeah, it's actually, we should have then a technological advance that should enable individualized price comparison. Because we don't have that. We have a price comparison in the traditional traditional way. But maybe this will be a challenge to protect consumers as a tool, making them enabling to have real-time individualized price comparison. We don't have that yet. So I would like to make my second question, because it's related to many things that were also approached in our discussion, which is about transparency. We have the discussion on exploitative abuse, where there was an interplay with data protection law, for instance, in the Facebook WhatsApp case, where the excess of data was compared. There was an analogy of excess pricing as an exploitation, with the excess of data as a sort of exploitation. So we have now, at least we have in Europe, this effort of regulation, which involves not only the Digital Markets Act, but also it involves the regulation of AI. And one of the key aspects of the regulation of AI is transparency. We also have the Article 22 of the GDPR, but it's also related with the use of automated decision-making, and pricing is one sort of automated decision-making. And what occurred to me is within these regulations about transparency, and the transparency should not only be about the use of AI, but also bringing and being transparent about the relevant criteria for automated decision making. So I wonder if lack of transparency in this aspect, which may be a violation of the future regulation of AI, couldn't also be a new sort of exploitative abuse. There was a lot of polemics about the Facebook WhatsApp case, whether the violation of data protection law shouldn't be only a violation of data protection law and not an antitrust violation. But regarding transparency, if we look to the regulation of AI that is coming, then we would have a problem about the transparency regarding the criteria for pricing. And I wonder if this one wouldn't be another sort of exploitative abuse, adding to those that you have discussed.
Thank you, Juliano. So that's a really good point, and it really shows us what we need to start thinking about next. And it's what type of abuse could we see in algorithmic discriminatory pricing? And here we'll need to think outside the box a bit, not just when it comes to what the relevant market is, but also what theory of harm we should apply here. Whether it's a lack of transparency or exploiting individual willingness to pay, the use of data that's been, volunteered for other purposes and is then repurposed. I think there's a lot to think about here. There's no conclusions there yet, I think, but it's definitely something that we should discuss. Now, the lack of transparency, I think the question is where would the threshold for abuse be? How transparent do companies need to be? And you also mentioned the Facebook case in Germany with this data protection aspect. And I think that's something that will come and play a role here more and more. How do those areas of the law interact? How should they interact? And how also do the institutions that protect competition, that protect data and privacy, how should they interact when it comes to those cases? Because they're closely interrelated. And if the authorities are in their silos and not communicating enough, I think that can actually lead to consumer harm. And so that perhaps is a good next step to say, well, we need to relate those bodies of law more fully. And like you said, also AI regulation, the GDPR in Europe is definitely something that it can't stay in its silo and not have an effect on competition law. That's simply not how things will get working, let's say.
Yeah. This is something really to think about.
Great. Well, I think it's time to say goodbye. It was great, Vicky, to have you here. It was really very interesting discussions and very interesting things to think about. I would like to say thanks to you. And in our next episode on December 19th, we will discuss the Brazilian bill to regulate digital platforms. So I would like to invite everybody to be with us.
I think that next week, Vicky, you're going to be more enabled to participate and engage in this debate in Portuguese.
I still have a lot of learning for that to do. But for now, let me say thank you so much for having me and for this really nice discussion, and hope to see you again soon.
Thank you.
Thank you very much. It was a pleasure and really illuminating to have your presentation, this discussion with you.
Thank you. Bye.
Bye.
Thank you. Bye-bye.